All right. Good afternoon, everybody. It's such a pleasure to be here with Saba and be able to look at some of the trends we're seeing in employment, but also how are we grappling as South Asian lawyers and stakeholders who are working on issues of both employers and employee rights around the issue of caste and some of the other intersectional identities that come up within the South Asian community. And joining us today, we have experts who are coming at this issue from multiple disciplines as well as multiple intersectional identities. So we're going to just go ahead and get started. And so our first expert, Rena, is going to talk a little bit about the work that she does. So Rena, I'd love to invite you in.
Thanks so much for that warm welcome. Hello, everyone. I hope everybody's having a good evening. Thanks for joining us. My name is Reena Bajwala. I'm a partner in the Chicago office of the law firm Ice Miller. My practice is at the intersection of law and technology, but considers the business issues as well. I also have an employment background. So even though I'm not an employment lawyer per se, I am versed in some of the issues that our employers are dealing with, mostly on the management side. So I am going to cover the sort of two main areas in which I practice and how they intersect with employment issues. And those are cybersecurity and privacy. A lot has been going on in both of those areas. So I thought I'd just touch on a couple of cybersecurity trends and then turn to a couple of different privacy issues and updates which we can expect to see in 2022. So first, I think the world has changed, right, over the last couple of years. I think every every panel I've been on has started there, right, because it's the elephant in the room, and that's the world we live in. Overnight, our workforces went remote. We started using new technologies. We started using new collaboration tools. And now here we are, 20 or so months into the pandemic, and employers are looking at, well, what does return to work look like, right? So you have some workforces that are going to stay remote completely. And then you have some workforces that I think are going to be in 3 or 4 days a week, or, maybe there's some that are 5 days a week, but you're seeing a lot of hybrid schedules, right? So you're seeing some people that are going to be logging into systems from their home, some from their workplace. There are going to be personal devices that are used. And then there are also this proliferation of new IT solutions and tools that are used so that, when you do have a meeting where some of the people are in person and some of the people are remote, you need to be able to, collaborate with each other. And so that raises a whole host of questions from the cybersecurity side and the IT side about, well, what are the parameters for those employees? So one of the expectations in a lot of work that I've been doing over the last few months, and I expect to increase in 2022, is looking at our information technology policies that are employee facing. So some of those that you might want to look at as employers are, an acceptable use policy. Acceptable use policy is a policy that sets out what is allowed and what's not allowed on IT solutions that are provided by your organization. Whenever the IT landscape changes, though, and you have new and different tools and devices that you're using, it's really important to go back and take a look. So for example, some employers have implemented Teams and are using Teams as not only a collaboration tool internally, but with other business partners. Now, understanding, well, can trade secrets be discussed on those with the business partners? Who's setting up those channels? How do you preserve that information? Really thinking through now that things are starting to get into some sort of settled, hardened state, but that state looks completely different from what it looked like in 2019. Revisiting those policies is really important. Also looking at your mobile device management or your bring your own device policies and looking at the security. It's really important as we're changing the shape of everything to ensure that these devices are secure. And that leads me to my second trend for cybersecurity, which will probably not surprise anyone, but the number of cybersecurity risks and data security incidents that have occurred has skyrocketed over the last 20 months. And even today, I don't know if people are dealing with this. Kronos, which is a payroll system, got hit with a ransomware attack, and they say they're not going to be up again for another maybe several weeks. And so people are dealing with payroll, how to do W-2s, the enormous cost that it's going to, we don't know right now if there is going to be a outward facing disclosure. There was an unauthorized disclosure of the information. Right now, we just know that there was a ransomware and the system is locked up, but that is going to be an area of real importance. So one of the recommendations I'd have is to amp up on your anti-phishing training. You have this, again, hybrid workforce, and so you're gonna need to be able to call the balls and strikes when you see these emails and ensure that you're not clicking on something that you shouldn't. And so, especially, I think a phishing simulation is one of the best tools to ensure that when people are, when employees are working, they know how to, are trained how to identify the right emails to avoid clicking on. And there are some really interesting disciplinary, I would say, maybe that's too strong of a word, but consequences for clicking on those emails that I've seen. So, it could be that you have to do more training. It could be that an email goes to your manager about that, and then that's on their radar. I've even seen for repeat offenders where they've taken the employee off of direct deposit. So you can imagine how frustrating that would be to take the actual check and have to go into the bank. So I think then my time is up for right now. Okay, so I can circle back to some privacy related updates if we have time later, but I think I'm turning it over, I believe, to Abhiman.
Yes, and Abhiman is going to be sharing with us a little bit about the technology used during hiring processes and onboarding, as well as looking ahead about some of the issues that are coming up with the metaverse. So Abhiman, the floor is yours.
Hey everyone, Abhiman Rajadurai. I'm on the labor and employment team here at McDonald's, currently starting up an 18-month stint as Assistant General Counsel for our McDonald's corporate-owned restaurants here in the U.S., so getting a good glimpse of projects across the legal space and business. And technology is a big part of that. One of the things that we've been looking at are technologies to help with hiring, retention, especially in our industry, but I think in some other industries there's a tight labor market. How can we attract talent that wants to stay here, work with us, or we'll be in this perpetual cycle of trying to hire new folks. So technology has made a lot of advances in those steps. We've definitely piloted with technology that's asking applicants for kind of more questions up front. I won't pretend to know all the ins and outs of the details, but I know the questions try to help around personality, like who would fit into the restaurant atmosphere. But along with those kind of benefits of technology are risks. Is this technology really working? Could it be discriminating against a certain group of folks, whether it's age, demographics, financial background? These are all issues you need to look into if your companies are looking into this space of using technology to help with hiring. But did want to reflect and point out that there are a lot of cool technologies out there that could, in theory, help. I mean, it's too early to tell, I think, on how some of these are going to work, but they might be benefits that your companies want to look into, or your outside, your clients, if you're outside counsel, like, hey, have you seen this technology might help you with this issue? And I can help guide you down a legal path to make sure you don't have any pitfalls. If you do go that route, one thing we looked into obviously was ADA, accommodations that would have to be made. What if, someone doesn't have access to a smartphone, other tools? What if they just don't have the bandwidth? Some of these tools that we were looking at, you had to answer very quickly. Like the systems will take into account how quickly you answer one way or the other. But what if you have a slower connection from a Wi-Fi or data package? That might influence how the results come out. So with all the benefits, like I said, with the technology, there's some risks that you have to look into as well. Outside of that, it's probably no surprise to a lot of you you folks, we don't use this here at McDonald's, but I've seen technology that can help with HR processes as well. One-on-one kind of a bot that'll talk to you. It's actually looks like a person animated. That'll help, process claims, get all the information up front, which is all meant to drive efficiency, right? Once you get those cases, from the bot, then you can assess them. You don't have to do the upfront steps. So there's a lot of cool technology there. But again, kind of same thing. Outside of legal risks, involved there, it's also like a personality issue. Is that kind of the one-on-one touch point you want to have with your employees, kind of this impersonal feel where someone is requesting time off for a loved one or their own health issue. So again, cool technology, but there's maybe some risks to work around, not just legally, but also from a personal touch point perspective. Again, accessibility issues there too. Are you able to accommodate for folks who can't use the technology? So just things to keep in mind while you're advising clients, or if you're advising your business, clients about this as well. And then the topic that's pretty new to me, and I thought would be interesting for this group, it kind of follows what Rena was talking about with this remote workplace culture, and that's the metaverse. You hear all about the metaverse and it's coming. And like I said, I'm still a beginner in this space, but it's very fascinating. Outside of remote working, if you go into this metaverse space, this virtual reality space, you could be a remote worker while you're in the office because you're going into your own metaverse. Who have you invited in there? What's the backdrop? What's the background? It's a very fascinating topic. The benefits, for those who aren't too familiar with it, haven't dug in like I have on my random evenings, is it's supposed to help with deep work. A lot of times we're distracted by things here at the office. If you go into your virtual reality space, you might have a coffee shop and you're just in your zone working. So it's pretty interesting from that perspective, but then why wouldn't you just work from home? It's a very interesting subject to look at. But also, it triggered for me, maybe there's discrimination. Maybe it's like, who do you invite to your metaverse? How are you setting up these meetings? What is the backdrop? Are you making people comfortable? If you invited, who knows, maybe you set up a club atmosphere that makes you work better, but you invite 3 folks and they're like, what am I looking at here? But from all the articles I've read on this, it sounds like they really do want to build, a lot of these tech companies want to build metaverses for people to have virtual reality spaces, and that it could come into the corporate culture as well. So I did want to flag that for you. Uh-oh, they must not want me to talk anymore here. Apologize for that. But it's very fascinating. And I think for us as attorneys who are in this employment and tech space, we have to be able to advise clients who are pushing for these technologies and employees who are demanding flexibility. I don't think we're in a place where we can give hard no's, unless it's illegal, obviously, but got to work to find a solution and a way to make these various work alternatives work. So, it's been pretty fascinating. The last few weeks I've been looking into this metaverse. I feel like the articles on this topic have really taken off. I don't think a lot of people have looked at it from a labor and employment risk, but I highly recommend you do if you're in this capacity, as in-house counsel or outside counsel. So just want to give a high-level update for now, but of course can answer questions at the end. I think we're leaving some time there for that too, but really fascinating stuff on the tech side right now.
Definitely. And thank you for that overview, Abhiman, because I think that many folks here are thinking about some of the strategies that they need to think about for their clients, and that note about the metaverse, as well as what Rena was talking about in terms of increased cybersecurity threats, are really terrains we want to make sure people are receiving support around. So thank you so much for that. I'd like to also bring in our colleague Assad, who is going to be talking a little bit about the role of the council, navigating the COVID-19 pandemic, particularly as he's done this in-house at Panasonic over the last 2 years. So Assad, we'd love to hear your perspective from what you've had to manage in terms of crisis, but also hopefully some possibility in terms of your work with your clients. So take it away.
Thank you so much, everyone, and good evening, everyone here. So my name is Assad Rizvi. I'm Counsel Labor Employment at Panasonic North America. We're headquartered in Newark, New Jersey. We're affiliated with Panasonic Global Corporation in Osaka, Japan. Been in this role for close to 3 years now, but more than half of it has been really navigating the COVID-19 pandemic and just being extremely nimble and reacting to all the multiple issues that we're still dealing with today in response to this kind of unprecedented time, really. So I want to share a deck just to explain all the various issues that we've had to navigate and how critical Labor Employment Council have been during this time. So let me just do that here. Okay. So, I mean, just to recap, and I know a lot of the folks listening and then my co-panelists are aware, this crisis obviously is unprecedented. L&E lawyers have played a pivotal role, at least I can tell from my experience at Panasonic, in helping the business react to this crisis. We've had to learn overnight to navigate public health guidance, learn about things like the CDC and various state and local departments of health that as labor employment lawyers, we'd have no understanding about. And translate it to workplace health and safety and actually make it sense for the business. And health and safety, of course, has become the number one consideration in this pandemic. And it's something that we've been very closely advising the company at Panasonic and other counsel across the country and the globe really have really been focused on the subject, looking at local rules. So just a little overview about what we did initially, and this is kind of going in chronological fashion, and just looking at this deck and doing it in the past day or two, I realized how much we've really done in the COVID crisis just these past 2 years, starting in March of 2020. So the first challenge was helping transition to a remote workplace, which some of my co-panelists have talked about. It was an extremely challenging thing for a company that had some sort of hybrid environment, but did not ever actually have to imagine a workplace that was almost fully remote for an extended period of time. Like many other employers, we have also transitioned or will be transitioning more officially to a hybrid kind of environment. We're still in the remote phase for those jobs that can be performed remotely. Panasonic is a very diverse business. We have factories, we have labs. So those places have been going on strong in person throughout the crisis. But back office support, operations, legal, we've been working and navigating through this crisis remotely during this whole almost 2-year time period. A lot of the work in the beginning was just determining essential versus non-essential industries. As you may all recall, various states had shutdown orders and only essential things like manufacturing, healthcare, groceries, things like that were allowed to stay open. We had to navigate through that. We had to kind of thread the needle to make sure and make the case that our businesses were essential to the economy, to make sure that we could thrive during this really difficult time. So that included things, as small as providing safe passage letters to factory workers who had to go in, so police wouldn't stop them during a lockdown in a particular state, or advocating to, performing advocacy work to make the case for a particular state government that our work is actually essential to the economy and should fit within this particular bucket that under a particular executive order in a state. And then the next big part of the challenge was reacting to the huge pieces of federal legislation that came down the pipeline, very relevant to the L&E work that we do. The first was the Families First Coronavirus Response Act. This was kind of an emergency paid sick leave and leave of absence rule that many of you are familiar with, that provided just the amount of time you need to quarantine, 2-week period of paid leave and job protection in the event that you were exposed to the virus, and provide that additional measure of security. And then we had the CARES Act, of course, which everyone's familiar with, which include not the Paycheck Protection Program, and included things like enhanced unemployment benefits, kind of things that we're still responding to in today's climate. The whole idea of a labor shortage, many have traced back to a lot of these pieces of legislation, and the enhanced unemployment in other areas. Access to 401k without penalty. All these pieces of legislation really did hit the employee experience. It was a direct, really attack on an ability of an employee to earn an income during this crisis. So we, as counsel, had to navigate and help explain to the company and to the business how we would provide these benefits while maintaining compliance with these various regulations coming down. And with the Biden administration, we had other large pieces of legislation, such as the American Rescue Plan Act, which provided emergency COBRA relief, unemployment assistance, paid tax leave credit for employers providing vaccine PTO. And then on top of the federal piece, as labor employment lawyers know, we also have the complexity of dealing with state and local laws. Panasonic being a 50-state organization, like many of the companies that my co-panelists are involved with, we're always involved in that complexity as well. So not only are we charged with making sure that we're on top of the federal law, we also have to be wary of places like California, Texas, New York, which have very complex, legislation sometimes in the area of labor employment. So we were doing things that we'd never done before as labor employment lawyers, providing guidance on travel, looking at State Department rules on which countries have a higher risk for our business people to travel to, which states have post-travel quarantine restrictions. There were so many different things that we had to react to and be really nimble during this really unprecedented time. And moving forward deeper into the crisis, going back into the workplace. So putting together return to work playbooks, looking at guidance on face coverings, masking and social distancing, reimagining the workplace, like many of my co-panelists have talked about, both physically and virtually as well. Ways to social distance, creating partitions, all the minutia we would never really have to think about, but we actually did have to counsel from where we stood as employment counsel to make sure that the businesses could actually work through this crisis in a way that was functional and that would protect employee health and safety. Ensuring confidentiality of medical information, of course, something that you're always mindful of as an employment lawyer. Medical information was something that we haven't talked about as much before historically as we are now in the employment space. We're always talking about someone's exposure, whether someone's vaccinated, all things that the ADA really captures that we had to be mindful of. And keeping on top, of course, of local legislation, in some cases prohibiting masking, prohibiting local rules. The beauty of our federal system is that there's so much complexity, whereas you could impose certain policies in a certain part of the country and you can't in other parts of the country. So dealing with that and navigating that was quite a challenge and something that we had to get through. Then moving forward with obviously the breakthrough in the emergency use authorization of the Moderna, Pfizer, and Johnson & Johnson vaccines, that opened up a whole new Pandora's box of issues for employment lawyers. We had to now think about ways we could encourage our workforce to get vaccinated so we could get back to quote unquote normal, protect employee health and safety. So the EEOC was very helpful during this whole year and a half. They provided guidance as new developments occurred in the public health space. When the vaccines were issued, the EEOC very clearly said vaccination can be a condition of employment. There's nothing per se unlawful about that, as long as you're addressing accommodations on religion and medical and disability grounds. So I know we're still dealing with that, and I'll talk a little bit more about vaccine mandates and those kind of challenges. But we did get good guidance from the EEOC as we moved into this new world or new stage of the COVID-19 crisis. Fewer employers at that beginning stage, if you'll recall, early 2021, you didn't hear many companies mandating vaccine. It was more about the vaccines are here, let's get in line, let's get vaccinated. It was hard to find appointments in those early stages. The idea was we thought most of America would be vaccinated by Independence Day. Of course, that didn't happen. I mean, we did have a good sizable majority of the country getting vaccinated, but we still have tens of millions unvaccinated in the country. And in light of that, some of the policy, both at the governmental level and at the business level, moved towards mandating, which we'll talk about in the next slide. But staying on the vaccine incentive piece, the EEOC, again, trying to stay on top of the new developments, talked about what kind of incentives are lawful. So in essence, they said, if you're providing incentives for employees to get vaccinated offsite, you can give them basically the world, give them anything you want, a huge bonus, PTO, cash, gifts, it doesn't matter, nothing is unlawful, as long as it's applied in a non-discriminatory fashion. But once you start administering vaccine clinics on site, are much more hands-on the provision of vaccines, then you have to be a little more careful about what kind of incentives you're providing. It can't be so substantial, let's say like, a $5,000 bonus or something like that, that it almost becomes coercive and doesn't give the employee a choice in that incentive equation. So we always, like I said, the EEOC was updating guidance throughout this crisis, and it still is, as we have new developments in this space. So as the vaccination rates started slowing down, summer and fall of 2021, we started seeing companies, starting really in the airline space and of course the health sector, starting mandating vaccination as a condition of employment, kind of leveraging what the EEOC said for close to a year at that point, that vaccination can be lawfully a condition of employment as long as you're accommodating folks who have a right to be accommodated. So what you start seeing with the larger Fortune 500 companies, larger companies starting imposing mandates. Of course, you saw lawsuits across the country. A lot of litigation kind of basically prevailed and showed that the idea of an employer, mandating is perfectly lawful. But we'll get to other legislation which kind of went the other way in a moment. But those early cases, and historically as well, when you talk about the flu vaccine and other kinds of employment-based vaccination programs, the employers have had that right in the at-will employment situation to mandate vaccination as a condition of employment. So what happened at this stage, of course, in the fall of 2021 is that the White House had the Path Out of the Pandemic plan, which had two major pieces of labor employment legislation. One was the federal contractor vaccination mandate, and the other was the OSHA emergency temporary standard, both things which have taken most of my time in the last 3-4 months, navigating and helping the business comply and work around. But as most large businesses, the company I work for is involved both in federal contractors, and the OSHA rule is clearly applies as it applies to more than 80 million workers across the country. Which really just says you must mandate vaccination, and you may allow for a testing option if you're an employer that employs at least 100 or more employees. And we'll get into that a little bit more. So just real quickly on the executive order that talked about mandating vaccination, it was a very sweeping piece of law coming from the executive level. It mandated that all employees who work in certain covered federal contracts or subcontracts must be fully vaccinated. There is no testing option. Originally, the deadline was January 18th. There's obviously a stay in place now, which we'll talk about in a moment, subject to your normal accommodations under the ADA and Title VII. It was so broad that even employees that work fully from home 100% of the time, so long as they're performing in furtherance of a federal contract that's covered by the executive order, they too had to be fully vaccinated. And even further, if you work in the same building and are co-located with an employee who works on a covered federal contract, you too have to get vaccinated. It was a very sweeping piece of legislation, which I think the Biden administration was using full force of the federal government and its contractual power to encourage and basically accelerate the vaccination rates across the country, pursuant to the Procurement Act and other various pieces of federal contract legislation. Then on the other hand, you have the OSHA ETS, another Biden law, which is currently stayed by federal courts. So the OSHA ETS is your private employer. You don't have to be involved in federal contracts. As long as you have 100 more employees, you have to comply. The idea was you have to mandate vaccination, but you could provide a testing option. And that testing option had to be done at least weekly for employees who report weekly to any work site. And this did not apply, unlike the federal contractor mandate, to remote workers. The trigger was you had to be out on site. You, as the employer, did not have to pay for the weekly testing, which was a sigh of relief for a lot of employers. And there was also an incentive piece. You have to provide a pay time off for employees to get vaccinated. There's a whole litany of rules around record keeping and producing records to OSHA inspectors upon, in some cases, as little as 4 hours notice. It basically created a very complex rule, and it did it outside the normal notice and comment rulemaking process and in the form of an emergency temporary standard. And it's part of the reason why it got challenged in federal court and currently has stayed. Historically, OSHA does not have a very good track record of actually defending ETS rules. I think there's only been one rule historically that OSHA has been able to defend in court. So it doesn't look good for this one as well. And right now, as everyone knows, this is also stayed. So real briefly, where's the OSHA ETS today? As far as litigation, the Fifth Circuit has issued a nationwide stay. Basically, the holding was that ETS is not necessary to prevent employees from a grave danger. The court said that the virus is not particular to any workplace and is not life-threatening to a vast majority of employees. Ordered OSHA to take absolutely no steps to enforce the mandate pending adequate judicial review of underlying motions and permanently enjoin the ETS. OSHA in response has said, we're not doing anything. We're not implementing this rule at all, pending litigation. The Sixth Circuit then won a lottery at the multi-district panel in litigation, and they're now going to be deciding where this goes. They may either lift the stay or they may affirm what the Fifth Circuit did. It may also go up to the Supreme Court ultimately. The briefing has been completed. Right now, to the extent that the prior deadlines are put in place, January 4th would be the deadline for someone to get vaccinated or accept a weekly testing regime. So that's kind of where we are now. Everything's on standby. We may get a decision from the Sixth Circuit any day now. A federal contractor mandate, also another loss for Biden, at least for now. That was stayed by a federal court in Georgia. There was a stay and an injunction issued with nationwide effect. That has been appealed to the 11th Circuit Court of Appeals. Biden administration is arguing that they have the power under the Federal Property and Administrative Services Act to issue this kind of rule as a matter of contract. Remember that the vaccine mandates under the federal contractor mandate, it's a function of contract. So if you want to do business with the federal government, your employees must get vaccinated. So it works a little different from the way OSHA issued its rules around its own legislative powers. So again, there are no deadlines, so to speak, but many companies in any event are preparing both for the OSHA ETS rule and the federal contractor mandate. To the extent that it does survive all these legal challenges, companies are preparing night and day really to make sure that they're compliant. And on top of that, the complexity of state law issues, given the stay, particularly of these both federal rules, which normally would get respect under the principle of preemption, now you have to look to and really look at the state law rules, which are in many cases speak to vaccination mandates and really prevent employers from providing effective mandates. These are just examples. Some of these states go even above this. So Montana is the strictest. There's no real ability for a private employer to mandate vaccine as a condition of employment. Tennessee, you cannot ask employees you can't require employees to provide proof of vaccine. Employees in Texas and Tennessee can also say, I don't want to take the vaccine for any reason. It doesn't have to be a disability, it doesn't have to be a sincere religious belief, and you have to respect that. In Texas, you can claim exemption if you've had COVID before, which is not necessarily accepted under a typical medical or scientific kind of reasoning. You can also object under personal conscience, very open-ended. Arkansas, you can be exempt from a mandatory vaccination if you accept if you stipulate to antibody testing. Kansas, you basically can raise your hand and say it's against my religion, and you don't have to go further than that. You sign it on a piece of paper. The employer has to honor that and exempt you from a mandatory vaccine policy. Florida, you can agree to wear masking and doing social distancing or agree to testing. As long as you're agreeing to those alternative measures, an employer cannot force vaccination on you as a condition of employment. So as you can see, there's a lot of state law complex issues. The religious exemption issue is also very interesting. I don't go into it too much in depth now, but you are seeing labor employment lawyers, companies navigating, religious objections to vaccines, which is something that we really haven't seen before. And many companies are forming committees and really making sure that they're doing the correct interactive process when someone says that something in the vaccine is against their religious belief. Of course, there's limitations on how much you can push back under Title VII with respect to the sincerity of someone's religious belief. But that said, the EEOC has guidance in this area as well. If it's a personal, political, economic, social kind of objection, that holds no water and has no legal foundation for a religious-based exemption under Title VII.
So Assad, I just wanted
yeah.
to just break in there because we
Sure.
actually have to continue on with the rest of the panel, but we did have questions about people being able to receive your deck afterwards. And so,
Sure.
So for folks that had asked for that, we'll definitely make sure that folks can get it as part of the folks at RSVP'd, and we'll also be able to, go into more depth if people have questions about Assad's presentation related to vaccines. There was a lot of chatter about it too. So So we want to make sure that people have that time for questions. So
Perfect.
thank you again for that,
Yeah.
of that overview. And so I will go next as one of the last speakers. And, again, my name is Thanmoi Soundarajan, and I'm Executive Director of Equality Labs. We are a Dalit civil rights organization that works on the issue of caste. And one of the things that we've actually seen within the tech sector and within the employment sector this year is an increasing amount of employers who are grappling with the issue of caste civil rights, with companies that have large South Asian bases, and also with companies that are looking to be greater in compliance with civil rights law. And there have been several cases that have looked at the issues of caste oppressed peoples. And I think one of the first cases to really look at caste in the workplace happened in the early 2000s when Lucky Bali Reddy, who was a very large landlord and restaurateur in the Bay Area, began trafficking caste oppressed employees into the city of Berkeley. And over the course of his work, like he basically trafficked close to 200 employees, a good dozen of them who were young girls who he was sexually exploiting. And because of that case, that really was one of the first immigrant rights cases that we saw that also had impacts in terms of both trafficking and employment law, because of the way that he used H-1B visas, the kinds of conditions that several of his workers were dealing with, and also the aftermath in terms of what happened with the survivors of that case. And since then, we've seen lots of other cases come forward with the issue of caste. And most recently during the pandemic, we've seen the state of California's Department of Fairness and Employment and Housing, suing Cisco Corporation, an American corporation, for caste discrimination. And it's the first time that's happened in American history. And many people are following that case pretty avidly because, again, with the DFEH, they do not bring litigation unless they've already done investigation. And the investigation related to the issue of caste, they didn't necessarily need to be historical experts of caste to understand civil rights violations, because many of the things that the John Doe was complaining about in that case are very much par for the course civil rights violations. He talked about, facing a hostile workplace. There were various attempts to identify his caste background. Once that was found out, he faced harassment from other employees. He was soon kind of siloed from work product and then put onto a pipeline of demotion and firing. And, again, this is a case that is in open litigation currently. But I think what it opened up was an entire conversation in terms of the tech sector of how employees are dealing with caste in their workplaces, and how can employers really move to address those harms. And in terms of our institution, one of the things that we've seen is that in our own data, that 2 out of 3 caste oppressed employees have expressed some form of casteist discrimination in the institutions that they work in. And as a result of the Cisco case, many corporations have been coming to our team to begin doing work around diversity and equity related to caste. And so I think for the folks here that are internal counsel for companies, I just want to really encourage folks to lean into this conversation. There's nothing illegal about adding caste as a protected category. It just helps bring your institution into greater compliance, because we have both, laws and covenants that we've signed at the international level in terms of existing civil rights law, and in terms of state codes. Caste, extending caste and making it an explicit category for non-discrimination policies really just helps caste oppressed stakeholders feel comfortable to reporting. Because, again, one of the things I thought that was so interesting in this period after the Cisco case is that we had numerous Dalits and other caste oppressed folks come towards us, sharing with us some of the cases that they were dealing with. And one of the most poignant statements that an employee said to me is that, well, why on earth would I even, report, an incident of caste at my workplace when they probably can't even find India on the map? So I think what's really important is that, as lawyers, you guys are basically some of the best collaborators for institutions around diversity and equity and initiative measures. And so once you've kind of done the legal work to make sure that the language is in compliance and you're limiting the liability with relationship to your clients, I think then that really then, can open up the next step of, once CAST is added as a protected category, all the other measures that come with that, which include data collection, training, and other forms of building both competency as well as, investments in terms of, increasing those talent pipelines of caste oppressed people into corporations. And this becomes really important because beyond the tech sector, we are also seeing other cases where caste is really coming forward. And there's a critical new case that just opened up, also, with an even greater scope this year, which is the case that was brought forward in New Jersey about BAPS Temple, in which they were trafficking Dalit workers to work for $1.20 an hour in very terrible conditions. And initially it was thought to be only in one temple in Robbinsville, but now it's been expanded to 5 other temples across the United States. And the civil rights firm that's bringing that litigation has also amended their complaint to add RICO charges to that. So it's a very serious issue. It's not limited to one industry. We're seeing it across many industries. And in terms of our civil rights work, we've definitely heard complaints from Dalits in tech, Dalits in other business and entrepreneurial sectors, especially facing some discrimination from venture capital. We're also hearing it in terms of working class positions, like people who are construction workers and restaurant workers. One restaurant worker actually shared with us that they were forced to sit on the floor while other people in the restaurant were able to sit at a table, and that there was untouchability practice even in the workplace. And even just today, we were in discussions with another workplace, and people were talking about how they had in their canteen where they had dining, they kept the meat next to the bathroom because they wanted to emphasize that eating meat was actually polluting. And so it's strange sometimes when we think about a system of exclusion like caste, we think of it as part of our homelands. We think of it maybe not operating here, but it's here. It's in our workplaces. And as councils, we have to deal with it. And luckily, we have incredible measures for DEI work that have really been developed, particularly in the wake of George Floyd's murder last year. And so I just really want to encourage the leadership here at SABA and the membership at SABA that, the councils here have a unique role in being able to help push this conversation with your clients and to be able to help helm this conversation in this space. Because what's really key to this is competency. And so when we build competency and that muscle for courageous conversations and are rooted in legal precedent and law, we can really move mountains together. And so I think this is a really important conversation that is only going to grow next year as the civil rights movement, just gets larger. Just last week, we saw graduate student workers win an amazing contract with Harvard that had caste as a protected category in their non-discrimination clause. And it's the first Ivy League school to have caste in its non-discrimination policies. And it's part of a bellwether moment where we're seeing institutions, big and small, really begin to join this movement. So I think there's, again, a really amazing role that SABA can play in really helping to be part of the institutions that flank this work. And whether on the employer side there's movement, workers are certainly moving and agitating on this issue. And so I think it's a really great moment to be able to support your clients to get in front of it and also be part of this historical moment. So I'll go ahead and I will open it up to questions and bring all of our panelists into the center so that folks can ask questions. And and I wanted to see, let's see, I'm looking at the chat. to see like what questions came up. So I know that the first question that came up in the chat was for you, Assad, and that was a question about for companies that oversees subsidiaries, how is your company handling government mandated mandates related to vaccines, particularly on a country to country level where that might shift?
So it's a great question. I only counsel the business both at the federal level and at the various state levels within the United States. So I don't have international exposure. We do have lawyers who look at what's going on in Europe and other parts of the world as well, where the rules are extremely different. In some cases, you can't ask for vaccine status. It's as a matter of privacy. So the rules are very different from the US. So I would, I can't really speak to that. But as far as the rules I discussed today, they're only really subject to U.S. federal contractors and U.S. employers. So they don't have any international really reach.
Thank you for that, Assad. And I think that there is another question from to Abhiman. And, Abhiman, one question people had about the metaverse was like, what are the kinds of issues that you could imagine that could emerge from some of the metaverse space, particularly as other folks here might be thinking about how to advise clients and think about norms in this space?
Yeah, I think, top of mind, it's probably a lot of the stuff you're already thinking about, the workplace seeping in. The virtual workspace is now part of your regular workforce. So discrimination, harassment, all those things are going to continue as if you were in the office. I think for me, what's giving me pause right now and how I want to think about this is from a people standpoint. Are you going to get a bunch of people in the office just kind of sitting there in their own metaverse? How often are they meeting with other people? Who are they calling into meetings? Will that create little factions or teams? It's stuff that could happen right now, but it's clearly going to have an option, like everyone will be in their own little metaverse. So I think things to think about is beyond kind of the legal topics, which I think all of us on the call are familiar with, is to the culture, the practical, like how it's going to be implemented. Like maybe companies can start setting up metaverses, maybe giving people 5 or 6 options. Here's how we're going to run meetings, trying to get ahead of the curve. So you can limit some of these issues that might come at a later point if you give employees too much flexibility. And the best analogy I probably have for that is, when the pandemic started, people were just moving. Like people were just going to Florida. They were going to Wyoming for a month. Some people went internationally that couldn't come back. So obviously didn't know a pandemic was coming, but since we know the metaverse is coming, maybe thinking ahead to how the technology could be used and setting some rules around how it can be used up front, even before it's something your company is even looking into.
Well, and I think that is really an important point, and it also is a nod to really bringing in Rena into the conversation, because I think one mistake that institutions make is deploying tech without policy, and that's just like a recipe for liability. And even when you think about a company like Metaverse, or like Meta or Facebook, you could argue that they basically unleashed social media tech on all of us without proper content moderation. And I think all of those issues related to hate speech and employee conduct really need to be considered when creating virtual spaces, because again, as the civil rights organization in this conversation, we've seen so much harm come out of social media with relation to caste oppressed and religious minorities from South Asian communities, that without that regulation, without that ensuring of safety and the duty of care towards those virtual realms, we could just see a replication of current harms, but that's why I think, Rena, I would love to maybe bring you in, because I know you didn't get to finish your thought, and if you want to basically bring up those additional points you had, but also really leave our folks with the trends that you're seeing from a technical perspective for 2022, that would be wonderful.
Yeah, thanks so much. Just a couple of things to look out for on the privacy end. I won't go into a great detail on it because I know this isn't the main focus, but it is important for employers to know. California Consumer Privacy Act was put in place in 2018, went effective in 2020, and was effective for consumers. And but most of the provisions as they relate to employees were delayed in their enforcement until 2023. So now next year is really going to be the time when companies are going to need to understand where their data, employee data is, what can you delete, what kind of responses to access requests and deletion requests and other informational requests that you need to put into place. So those procedures, get started now, because that's really going to be a big effort for 2022. Also, there's in May of 2022, there's a new law in New York regarding workplace monitoring and making disclosures around workplace monitoring. And I mean, this ties to a larger, sort of technology question and metaverse question and other sort of device and solution questions is what as employers, are these new tools doing to monitor employees? You need to understand the tech. So you just got to sit down with your information technology folks and say, okay, what does this do? Am I, without knowing, collecting information on my employees without disclosure? So you have this New York law, there's a Connecticut law. Usually in the US, it's pretty employer friendly in terms of monitoring. And by that, I mean, monitoring emails and communications and phone calls. Internationally, it's a much more complicated picture. So I think being really aware of what these new fancy gadgets we're using, what the implications are for employees and for privacy is going to be really important going forward.
Thank you so much for that. And, and again, I think that I saw some questions in terms of the question for you, Rena, which is, what is a good way to stay up to date on the latest in terms of privacy legislation?
Yeah, there are some certification bodies. So International Association of Privacy Professionals, IAPP, if you've seen all the CIP, CIPT, all those, I have a couple of those, but if you sign up for their listserv, they do a good job of collecting that thought leadership and providing alerts for when there are new laws or there are new bills that are moving along the pike. It's very hard to keep up with all of them, but I think that's one of the best ways. I also like Bloomberg Law. They have some really good focus on some of the issues. They're going to be sort of once they hit, but seeing things coming down the pike, I think IAPP is really one of the best sources. Or talk to your friendly privacy lawyer. We can keep you updated.
So Rena, I guess you're our next friendly privacy lawyer that people will be reaching out to. And Assad, I'm sure many people will be wanting to follow up with you as well in terms of the issues related to COVID, because those are some difficult things to manage as counsel. And it's really clear that you held that space really well. I wanted to answer a question about where we are in terms of the civil rights movement related to caste as a protected category. And currently, we have multiple states, as well as work on the federal level and at the district level, where different institutions are moving towards making caste explicit. And one correction I really want to make is caste is currently protected under the categories of race, national origin, and faith. And so the cases that have been brought forward are usually a mishmash of some articulation of that. However, I think similar to the trans community, what we're seeing is that caste oppressed people are expressing that they need the remedy that they need is really making that category explicit, given the fact that without that explicitness, there's no data collection, there's no insurance of competency. And in industries that are very South Asian heavy, like tech, we're just seeing it across all of the different kind of verticals of talent in that sector. And so I think this is a moment where we're seeing different institutions really just kind of trying to meet the moment and be able to kind of shift the discourse where they can, because there's nothing illegal about adding caste as a protected category, but the fact that so many institutions are doing it speak to the need of like federal policy shifts that need to occur. And there are certainly stakeholders that are working towards that. But I think at a basic employment level, one of the things I did want to share is that We've seen very large, both intergovernmental institutions as well as transnational, tech firms really just lean into this question of caste. And, having been in engagements now that are about 15 months old with certain corporations, it's a doable process. And not only is it doable, I think that there's a lot of transformation that's happening as we're seeing more South Asians feeling comfortable speaking about those dynamics. And one thing I thought that was so interesting, which I had not anticipated, was that, for most people that think about caste, caste is across all South Asian communities. So it's not just those that are of Indian descent, but we're seeing it from immigrants that are Pakistani, Bangladeshi, Sri Lankan, as well as Mauritius, but also people from indentured communities. So Indo-Fijian, Indo-Caribbean, and those who immigrated that were indentured from Africa. But the reason why I bring that up is that we see caste dynamics between caste oppressed faiths also. So one thing that I really was struck by, particularly in the state of New Jersey and in California, is that we heard of a lot of South Asian Muslims that were facing caste discrimination because they were seen as lower caste by dominant caste people from another faith, and it could be, many different faiths, but that was something that I just had not anticipated. But again, we're seeing many faiths, many faith backgrounds, particularly caste oppressed faiths within the South Asian community, really, express the need for remedy around these issues. So again, like if you're a council in an institution that is thinking about working on this issue or have heard similar complaints, like I think this is like an excellent place where HR and legal can really get ahead of an issue, but also, talk and have focus groups with your employees. Because what's interesting is that many employees are not using their internal mechanisms for reporting because of how taboo it is to talk about caste. If you think about even in other South Asian spaces, how frequently have you seen a Dalit person be on a panel, let alone talk about the level of discrimination that's occurring, or even how are we, dealing with our intersectional, accesses of, faith and gender and sexual orientation, as well as class and caste within our own South Asian community. So this is a moment, I think, again, Saba leaders can really, really be powerful forces for change. And because if we're comfortable with it, we can actually then transform the institutions that are beginning to be even more open to South Asian communities. So I think our hope is to really be able to be that bridge together, So thank you for that question. And I believe we are at time. And, I don't know if, our panelists would each like to maybe have a closing, like 30 seconds, so that each person could kind of leave people with a last thought. Abhiman, do you want to kick us off?
Sure. Tech is always changing. So I like to say, get ahead of it as early as you can. It's better to be proactive than reactive.
Okay, wonderful. And Abhiman, if you want to drop your contact info for people that want to reach out to you, that'd be great. Rena, your 30 seconds.
Sure. I mean, it's similar, but I think just be deliberate and be aware. As things are changing at rapid pace. It really makes sense to stop and do a risk assessment, understand where your data is, understand what these new fancy tools are going to mean for your employees, and act accordingly.
Okay, wonderful. And Assad?
So in conclusion, I don't want to end on a bad note, but it doesn't look like COVID is going anywhere. So as labor employment lawyers, I think you're very well aware of that. And I think one thing we can do is leverage all the lessons from reacting to this crisis for those last 2 years for future crisis management issues. Those lessons can be applied elsewhere as well as we deal with other issues going forward.
Wonderful. And then my last 30 seconds would be Jai Bhim. If folks haven't heard that phrase before, it's a slogan from Dr. Ambedkar, which is really an invitation to equity and to justice. And I think you're right, Assad, this is a hard moment that is filled with hard truths and difficulty. But I also think South Asians are incredibly resilient. And I think even in the face of great crisis, we always find those opportunities to be able to find hope. And so, in saying Jai Bhim, I really just want to bring us together to know, the amount of talent we have in our community can really turn the tides on so many of the issues that we talked about. As we go into a time of more volatility, I also hope it'll be one of great possibility, especially as we build towards rights and power and possibility in all of our institutions. So thank you all. And thank you, Saba, for hosting this conversation. I know that we'll be seeing different folks here in other future conversations. And thank you all to our attendees who participated. We'll be sending all of the links and follow up as well. So thank you very much. All right, then. Bye, everybody.
Thank you so much.
Bye, happy holidays.
Happy holidays.
Okay, Renee, do we have to stop the recording? I think. Let's see.
Oh, okay. Yep.
Okay, I think